original, mighty the god, the magical radical. Hey, representing my magical. Young Jose, come million. Jamaica, wacha, that difta. Kina teach me ni kenyo Jamaica kopa. That wacha, kina damage me ni kenyo Jamaica wacha. That difta, kina teach me ni kenyo Jamaica kopa. That difta, kina damage me ni kenyo.
Good morning, welcome to my YouTube channel. My name is David Okun. Thank you so much for coming to this platform. I'm so grateful. I've been talking about work in the United Kingdom. If you have watched this video, please watch with the rest of the videos which are connected to these videos. And at the beginning of this program, we have been talking about mainly the cost of living crisis. And if you remember, if you are a returning subscriber, or if you are been watching these videos now and again, then you will remember that we've been talking mainly about cost of living. Cost of living relates to income, and income maximization is in part in the fundamental solution to the cost of living crisis. But the cost of living crisis, like I said, is not really being discussed because of the cost of living necessarily. Because I have proposed or even argued that the cost of living is associated with the wider problem in the economy, also the wider problem in the communities, in societies, to do with culture, to do with development, to do with our mentalities. I have also said if we work for living, then we will succeed. If we don't work for living, we fail as individuals, as communities, families, and societies. That is why work is very important. I am talking about work in the United Kingdom. I have also said if something happens in the United Kingdom, then it also happens somewhere else. In your country, there are about between 5 and 7 continents, depending how you count these continents. And so it is extremely important that you find out what happened in your country. A lot of information now is on the government website, and it is so important that people actually do due diligence, especially young people living in one country or another, especially in Britain, especially in the developed world, but also in the developing world, such as continent such as Africa, and perhaps also South America. These are respective countries, but overall there is the growth of wealth around the world. There is the growth of technology also, where technology is now taking over work, but the disparity between the haves and the have-nots has been of major concern, and is the primary cause of the cost of living crisis, and employment is part of the solution. But in the United Kingdom, there is a major problem of low pay, which I also talk about. And if you know anything about payments in the UK, of wages, of salaries, then the comment below. And what you need for a solution is actually to create high quality jobs which have strong legal background backing for employee and also for employers, or an equitable providing a template for equitability as such. But the state of affairs existing now with the present employment platforms in the UK is where there is more power in the hands of the employers, and less power in the hands of employee necessarily. And that's why I've been looking at this material to justify my proposition that there is injustice, social injustice, and the economy being part of social welfare factor, and the same time as being a factor of the economy. And learning is extremely important. Our minds, our heads are designed to learn. We use our heads to learn, to think, and also to acquire knowledge so that we become wise people, wise individuals, and therefore we become resources. We become resourceful with resources enough to help us in situations, including situations of employment when there is dispute. And that is exactly what I'm trying to talk about, dispute, including claims. And for those who have been watching the video, thank you so much. And for those who have not been watching the video, thank you also so much, because you came today and you're watching this video. And if you have seen this video and you haven't actually come across it, my apologies, or actually also, I'm just happy that I'm here, and I'm also happy that I have access to the YouTube's facilities to participate on this platform. It has been very challenging but very rewarding as well, and you know, no pain, no gain. And therefore, you know, if you need to succeed, to repeat the point, you have to work, and work is what I'm talking about. I'm talking about the legal aspect of it. So it is, I find it extremely complicated. And if you find it less complicated, so be it, and you are one of those lucky people. But I would say development is one thing, and also the cultural economy is another. Our culture is the source of peace, because you see, every time we face a problem, including problem with dispute in employment, it means there is lack of peace. If you see leaders now are lying, they are committing crimes, like in America, political leaders, some of them are actually starting to be leaders. President of the United States being, you know, having a criminal, being criminals necessarily, because they are being convicted. They are convicted criminals. If you are a convicted criminal, I think it will come below. If you think you are a convicted criminal and you are not a criminal, or if you are a criminal, and if you're standing to be the president of America and you are actually a convicted criminal, I think you are also a criminal. And if America allows even a criminal to stand to be the president of America, then our culture is in trouble. And we are disrespectful of ourselves, we're disrespectful of our countries. America is a disgraceful country to allow somebody who is a criminal convict to stand for presidency. If such a person is elected, you are going to have a criminal being head of state of America. America is the leader of the global economies. Even in Africa, I mean, whether you are black or white, we look to America to lead the world. Democracy stands or falls with America. And if America now has decided that criminality is a good thing, is honorable to be a criminal, and also to be a thief. I mean, if you have a president who is a criminal, who might actually be in prison, and is in prison probably running the country from prison, how is such a leader be responsible for laws and orders to provide, you know, a peace in a country like America? If America fails, the globe fails with America. And if we fail to be respectful to, you know, because criminality is a form of immorality in terms of, is sin in terms of morality. If you take the word sin and translate it into the law, you find crime. If you commit crime, you are a sinner. Especially if you are Christian like myself. It is not. I mean, if we now say sin is the right thing to do, or crime is the right thing to do, I mean, why should people not commit crime? The law is in vain. The courts are in vain, because you see, you cannot convict a criminal and allows the same criminal in a country like America to stand for power in America. You cannot allow people who break laws, you know, potentially criminal laws, like we found with the Prime Minister of Britain during COVID-19, breaking the COVID rules, which is a type of crime. If they did not pay, they are fined. They are fined. They would have been, even the current Prime Minister was a potential criminal. They could have been convicted criminals. They were going to be convicted for not paying. Correct me if I'm wrong. Leave a comment below. if you have you break a COVID-19 rule during COVID-19 and you don't pay the fine, I think you're going to be criminal. A criminal, you're going to be convicted. If you're convicted as a criminal offender, then you're going to be a criminal with a criminal record. And that is the situation we're now having. And our prime minister, our former prime minister here, in the media everywhere, is being described as a liar. Somebody who is a liar should not be prime minister, should not be anywhere near, even, you know, to stand. I mean, if you are, if the word, you know, the word lying is associated with your name, and you're running America, you're running Britain, and we are talking about democracy, then we are in serious trouble. And that is what I'm saying. Our lives in our own hands. I'm not judging anyone, because I am just like you. Except my responsibility is not to run Britain, is not to run America. I may even break the law myself, maybe speeding or doing things like that. I mean, everybody is a potential criminal until the other court or the law changes. You see, there are laws which may be produced next year which will criminalize certain activity committed in this year. Acts which are non-criminal, it can be criminalized next year. So if you are committed the crime the following year, and if the law is retrospectively applied, then it depends how retrospective it is applicable in its applicability. What are you going to do? So we'll talk about our lives. And when I talk about work, I'm talking about our life. And it is so important. You only live once. I know engineers, not engineers, but, you know, scientists, let us say they're scientists, they're doing research to extend the lifespan of everyone. If that happens, then that is going to be a good thing for everybody, because we are going to live longer. Life is number one. And there are people who are also trying to bring people back from the dead. If they do, that is a starting point. It's a peace process, commanded by humanity. Now, we are not trying to play God. I'm a Christian. I worship God, and I know what God said. God created, if you read Genesis, God created us in His image. If we create things, we are being godly. We are behaving like God because we are created in God's image. God is the creator. We are also created. So we offer no apologies to sinners or to people who are contrary to progress. There is no excuse. If you are trying to do your work, but focus your work on humanity. Our life should be humanitarian. It should be human focused. There are people who now despise immigrants in the United Kingdom, in America. They are politicizing immigration. There are foreigners who are coming into these countries. They are weaponizing the idea of immigration because for political opportunism, confusing the British people, the American people, the Europeans, the people of the world. I'm not saying it's not happening in Africa. It is not happening in Africa, but in the West and also perhaps in the Eastern developed world, it is getting out of control. And if you hear politicians now campaigning and the way they talk about foreigners, especially Africans, when we talk about foreigners and we are Europeans, we are more or less talking about Africans, because Africans are so different. We are black and we are in Africa, and our culture is very, very different from Europeans. And Europeans are very similar to America and to Asia. In part, some part of Asian cultures are quite similar, especially in the Middle East, quite similar to African culture. So when we talk about foreigners, people we don't want in our country, I'm not saying Britain is not generous, but I mean, if people come to the UK and they're destitute, and still you have politicians deceiving the British people that the British people are poor because of foreigners. And you don't even know how many people come to the UK, for example. because we are actually at elections. At the moment, election is just next week in the United Kingdom on the 4th of July. And some politicians now are using immigration, racism. Let me say, immigration is now about racism. So they are actually, they're storing up racial hatred. Because if you suffer, and a politician, we believe in public figures, we believe in accusing foreigners, especially black people, or even Asians. Because, Africans are more alien than Asians. Asians are more alien than Europeans. So if there is a talk of foreigners in Britain, inadvertently, but also by implication, when they talk about Africans, that is an offense. They talk about black people, that is racism. And even if you talk about Jews, Gentiles, you talk about Asians, that is potentially you are committing racial offense without committing racial offense because of political opportunism, political violence, political insanity. This is what is happening. This is a broken culture. We can talk as much as we like. I've been watching a video this afternoon about female multimillionaires, Rihanna and all those, Oprah Winfrey. They are so rich. These people are so rich. But what you want to know is, if you go to a country like South Africa, in Soweto, I haven't been to Africa. If you have been to South Africa, leave a comment below. If you have been to Kenya, leave a comment below. In Kibera, in Kenya, in the slums of Africa, the slums of South America, places in Asia where people are so poor. India is so rich that to mention even poverty in India is so wrong, is so evil, is so wicked. And there is no peace for the wicked. So this is the introduction of this program. And please, I actually got this out of my chest. If you think I'm talking sense, leave a comment below. If you think I'm talking nonsense, leave a comment below. We are a work in progress. I am so grateful that we have this platform. We have YouTube channel. I'm so happy that we have YouTube channel, and so we are able to speak to the extent that the powers that be are allowing us to speak. So be it. If you're a YouTuber, if you're a content creator and you're watching this material, never give up as long as you are still allowed to speak. If you are not a content creator, if you are not a YouTuber, to the extent that you are allowed to speak, don't just sit there and say nothing. Speak. If you have family, if you have friends, if you have communities, form small group and talk about objective things. If you want to go onto the street to sell drugs or to take drugs or to commit crime, you are doing the wrong thing. And if you continue doing the wrong thing, you are going to get wrong results for yourself and for people around you. You are a human being. You are your brother and your sister's keeper. There is no two way around it. We talk of individualism, and that is fine. I have respect for individuals. I don't have respect for individuals who do not respect themselves, who do not respect other people. I may be lecturing you, but I'm also lecturing me, because I'm also in it. We are all in this together. We have to do the right thing. And if they try to stop you, continue speaking if you can. If you cannot, then you can maybe take a break or hide. They will still find you if you try to hide. I will say the people in power. Some people are so powerful. They have money, they have wealth, they can buy anything. They can buy somebody to kill you if you think you're talking against them. But you see, they are so rich, but they are so evil. I mean, if you are rich and there is a single person in a country like Britain where the government is so rich, the state has been collecting taxes, they have been taking land, they have been taking wealth from the British people and concentrating this in cities and towns. which is where the wealth are. That's why people congregate around cities and towns, because that's where wealth are. Then security is to protect wealth and to or protect the wealthy in the first place. In the second, to prevent poor people from stealing from the rich. It's an evil system. That's why the police in the United Kingdom or in America do not respect poor people. These street people are people on the street. They think they are criminals. They call you sir or madam in vain. And this culture must change. The police has been taught in a bad way because of violence, because of people who run the countries of the world, not just Britain, because they are wrong. And we are getting more and more. It's becoming cultural in terms of politics, but also in terms of business. Small and medium businesses are shutting down because they are poor. If you are poor, you face extinction. But you see, any human being causing the death, whether by poverty, using poverty to kill other people, if you allow poor people to die of poverty, because poor people cannot access healthcare. Because of privatization, healthcare is shutting down, dentistry is shutting down for poor people right now, and the poor people do not know about it. I don't know where they have been. The middle class who depend on credit are oblivious. They think they are doing very well. Well, if you think you're doing very well, fair. But the day the bank refuses to give you credit, even if you are working, that is the day you will know you are extremely poor, the day you lose your job. I'm not praying for that, but technology is going to take your job if you're in the middle class. If you're a technocrat, an accountant, lawyer, technology is coming. It's taking away your work. Once you lose your job, you cannot get benefits in the United Kingdom because the benefit system is shut. The housing are shut. Hospital is shut. Dentistry are shut down. The housing, if I haven't mentioned it, is shut. We can barely access food. There is something called food bank. It's completely an anathema. It's a complete insult. It's one of the worst surveys on humanity. Food bank is lethal. It's a very dangerous thing that the government has devised to put the final nail on the coffin of poor people in Britain. If Britain can do that, if you can treat its citizens as slaves, as dogs, even dogs being treated better, then you will see you are faced with an evil country. And if you think Britain is evil, go to Africa, go to America. The same thing. And it is about time, if you are out there, you are still a good person. Because goodness means you care about yourself, you care about other people. Some of these people are so rich, they are so powerful, they don't even care about their own lives. They live like wild animals. If you meet them abruptly, you don't think they abuse themselves. You don't even think they are rich. But there are good people among them, people in power. There are good people. I'm not saying poor people are good. Because some poor people are monsters. They are robbers on the street. They are murderers on the street. They are drug dealers on the street. They are in criminal gangs on the street. So are the rich. But the rich are not caught. If you are a poor person, you are a criminal, the police are at you. The police do not arrest rich people. If you are wealthy and a criminal, you walk away scot-free. Donald Trump is protected by the CIA. Lucky. Some people are more lucky about Donald Trump must be very miserable because if you're a multi-billionaire and you're still a criminal, and you're still standing to be elected. So let us stop this discussion here. Let us, because we live in hope. Nobody is anybody's God. We are humans. Doesn't matter if you are rich, if you are poor. We are humans, and we will speak, and we will win. You see, we are here to win. We are not here to fail. We will win. And this is the first part of this program. Is a prelude, is a summary of what I have been talking about. If you watch this video, watch the rest of the video and link it with this. This is a preview, this part. The second part is going to be talking about specifics, about employment, about work. It's about, I've been talking about pay now. If you watch the last video, I've provided an introductory, probably maybe an overview and a bit of specifics about pay in the United Kingdom. I'm so grateful that you actually attended this program. And if you haven't, these videos are always on my platform. One way or the other, we will meet again. If not soon, then later. Stay tuned, continue watching. So let's look at grievance procedure. An employee should raise a grievance against their employer if there is time to do so within the time limit before making a tribunal claim. We discussed time limit in the other materials. If you watch this video, watch a long time alongside the other videos produced previously on this material on this topic. So the grievance may help the employee to obtain useful information for an equal pay claim. The Court of Appeal has held that in an equal pay grievance, it is not necessary to identify the comparator with whom the employee is comparing themselves. It is sufficient for the grievance to say that it is a claim brought under the Equality Act 2010. Stay tuned, continue watching. You can look online if you want to know more about raising a grievance in England, Wales, and in Scotland. So in England, Wales, and Scotland, the Equality Act 2010 makes it unforeseeable, makes unenforceable any terms of employment, appointment, or service that prevent or restrict people from disclosing or seeking to disclose their pay to others, or terms that seek to prevent people from asking colleagues about their pay, where the purpose of any disclosure is to find out whether there is a connection between any difference in pay and a protected characteristic. Any action taken against an employee by the employer as a result of conduct protected by this section is treated as victimization. Stay tuned, continue watching. Generally, discussions about pay would take place between colleagues, but protection extends more widely to include, for example, disclosures made to a trade union official or anyone else, provided that it is made with a view to finding out whether any pay differences may be connected with protected characteristics. These discussions are relevant, called relevant pay disclosures. Stay tuned, continue watching. You can find out more about what are protected characteristics or victimization online. A female employee thinks, this is an example, thinking she is underpaid compared with a male colleague. She asks him what he is paid, and he tells her the employer takes disciplinary action against the man as a result. The man can bring a claim of for victimization against the employer for disciplining him. Leave a comment below, let me know. Example 2, a female employee who discloses her pay to one of our employers, competitors with a view to getting a better offer could be in breach of a confidentiality clause in our contract. The employer can take action against in relation to that breach. Talk about contract and the intricacy involving such rules. Example, a discussion between an employee who is a disabled person and a non-disabled colleague for the purposes of establishing whether the non-disabled person is being paid more than the disabled person could involve a relevant pay disclosure. However, two non-disabled colleagues simply comparing their respective salaries are likely to be making relevant pay disclosure unless they are investigating pay disparities which may be linked to race or another protected characteristics. Stay tuned, continue watching. So let us look at employers' defense. Even if a worker establishes that they are doing equal work, their employer may still be able to argue that there is a material factor which justifies the difference in pay and does not constitute discrimination because of sex. Leave a comment below, let me know what you think about these situations. So the factor can relate to qualities personal to the workers concerned, for example, skills, experience, or qualifications, or to external consideration, for example, market forces. Stay tuned, continue watching to establish that a factor is a material factor. The employer must show that the factor existed when the equal work commenced and continued to the date of the hearing, is significant and relevant to the difference in pay. Truly explained, the difference in pay does not discriminate directly, does not discriminate indirectly, or if it does, this can be justified on an objective basis and can account for the whole of the difference in pay. It is very difficult to know what might or might not be a material factor. Each case will depend on its particular facts. For example, market forces are being held to be a valid defense in some cases but not in others, arguing that an employer cannot afford to pay a worker more even though their work is of equal value to their comparators. It's not likely to succeed. Stay tuned, continue watching. So employers must often use so employers have often used the fact that a worker does not work full-time or on a permanent contract to justify a difference in pay. This may be discriminatory and or a breach of the part-time workers regulation or fixed-term employees regulations. Stay tuned, continue watching, let me know your thoughts as well. You can actually search the internet to find out more about rights of part-time workers, rights of fixed-term work employees as well. If the employer has carried out a valid job evaluation scheme where one job has been rated lower than the comparators, a worker's claim cannot succeed unless the job evaluation scheme itself is shown to be discriminatory. Leave a comment below, let me know what your thinking is. unsuccessful defenses used by the employers, the Court of Appeal has held that it is no defense to an equal pay claim for an employer to argue that the pay structure is justified just because it was agreed by negotiation with a union representing the employee. The court said that the collective bargaining can lead to one group of employees being worse off than another, and anyone involved in collective bargaining should be aware of the possible impact of any agreement. For example, a new pay structure may have an adverse impact on one gender and therefore indirectly discriminate against that particular group of employees. In another case, the Court of Appeal held that pay differential which had arisen because of the predominantly male group had been paid bonuses to encourage productivity was tainted by sex discrimination. The work of the two groups had been rated as equivalent, but the gardeners and street cleaners, predominantly men, had been paid bonuses to encourage efficiency, whereas the carers, predominantly women, had not. Stay tuned, continue watching. The council argued that the carers' work could not be measured in a way that the gardeners or street cleaners' work could, so there was no discrimination, and it did not have to justify the difference in pay. The court disagreed and held that difference in pay had a disparate adverse impact on women, and that there was a strong history of gender stereotyping. So the reason for the difference in pay was discriminatory, and the council would have to show this was objectively justified. So the European Court of Justice has decided that the need to maintain good working relations can be a relevant factor in an employer's defense to an equal pay claim, but it cannot be the only reason. There must be other additional non-discriminatory reasons to justify a difference in pay between male and female workers who are doing equal work. If it is no defense to an equal pay claim for an employer to argue that, for example, a woman would be paid less but has a better overall package than a male competitor. Claims compare terms and conditions on a term-by-term basis. So if a woman is receiving lower pay for equal work, her pay should be brought up to the same level as that of a male competitor, even if all overall terms and conditions of employment are more favorable. Stay tuned, continue watching. So thank you so much. Let us now move forward to talking about pay in the United Kingdom, and we'll talk about length of service. Length of service relates to the length of time you have been working for your employer. You are an employee as an example. So we'll talk about work in the United Kingdom. And so if you live outside the United Kingdom, you can pay attention to what happened in the United Kingdom and compare what happened in the UK with what happened in your country. Because we are global communities, And what happened here happened elsewhere because of harmonization. Globalization is big. It's big on politics, policy, including employment policy. With policy and law I'm talking about. And I'm so grateful that you came. So let us look at length of service. How long have you been working for your employer? So that it's been long established that an employer could use length of service as a justification for a difference in pay. Leave a comment below if you are a woman. However, this could disadvantage women who are more likely to have shorter length of service because they have been on maternity leave, for example. Women get pregnant, men do not. So by policy, which is actually blanket, women are inadvertently discriminated against. Leave a comment below if you're a woman, if you're a man. So despite this, the European Court of Justice, ECJ, decided that length of service is a criterion which an employer can use to justify a difference in pay, as it is a legitimate objective to reward experience and enables the worker to perform their duties better. So we talk about performance-related conditions. Leave a comment below if you think that is proper. Is proper in terms of business, management, in terms of development, but culturally, it could run the risk of being immoral. Immorality is not enshrined in law. When I talk about the law or policy, they are blind mentally or intellectually. In every aspect, they are blind to the idea of morality. Legality is the opposite of morality. Yet, the values protected by law is quite similar, if not the same, with the values protected by morality. Because if we talk about humanity as being of priority, then we, in terms of security, law, welfare, development, finance, we protect people first. However, the ECJ, as it is, went on to say that in any particular case, a worker may be able to raise serious doubt as to whether or not the aim is achieved. It is arguable that while there may be a difference between what a worker with 2 years experience can do compared with what one with 10 years experience can do, there may well be little, if any, difference between what a worker with 10 years experience can do compared with a worker with 15 years experience. Leave a comment below, stay tuned, continue watching. This is the manner and the nature of discussion and these types of arguments in law and policy in relation to length of service as contained in the English law of employment, of work. It remains to be seen how this judgment fits with the Equality Act 2010, which limits to 5 years the period for which an employer can use length of service in awarding benefits to workers without additional justification. Stay tuned, continue watching. So the Court of Appeal has set out guidance on when in equal pay claims an employer must justify the use of length of service as part of a pay progression scheme. So the court said that an employer should provide objective justification on their use of length of service criterion, as well as why they adopted the criterion in the first place. And so the employee must then show serious doubts about whether the criterion is appropriate to meet the employer's stated objectives. continue watching, stay tuned. Leave a comment below and let me know your thoughts. If they can do this, the employer must ensure that using the length of service criterion was appropriate. If you are going to make a claim in relation to this dispute, then an employee should raise a grievance against their employer if there is time to do so within the time limit before making a tribunal claim. We spoke about time limit in relation to dispute in terms of claim to as it is made to a tribunal claim. Leave a comment below. If you watch this video, watch with the rest of the video. To make an equal pay claim, the worker should submit an ET1 form to the employment tribunal. If applicable, they might also wish to bring a sex discrimination claim. You can access the internet to look more, to try to understand more about raising a grievance, more about how to make a claim to the employment tribunal, more about making a sex discrimination claim. Stay tuned, continue watching. Thank you so much. Let us also look at time limits in equal pay cases. In England, Wales, and Scotland, you must notify ACAS of your potential claim before you can make a claim to an employment tribunal. The only conciliation procedure applies to most employment tribunals claims and will affect the time limit for those claims. Leave a comment below, stay tuned, continue watching. You can access the internet to learn more about early conciliation, more about time limits in employment tribunal cases. Stay tuned, continue watching. So also a worker who wishes to bring an equal pay claim should do, and doing so during their employment, but also if they have left the job for which they wish to make the equal pay claim within 6 months of leaving the job for an employment tribunal claim, or 6 years of leaving the job if you 5 years in Scotland for a claim to the civil court. There is also special rules which applies to fixed terms contracts. You can look at that online, gov.uk and all the other available websites. As long as they are public, they are free, they are usable within the fair use context. Don't ask me about what fair use is, but if you go online, you'll probably find the legal meaning of fair use. So if a worker has different jobs with the same employer, they can make an equal pay claim in relation to any any of the jobs they have held with that employer at any time before leaving that employer. Therefore, an employer may deliberately conceal from the employee information which they would have needed to commence proceedings. In this case, the time limit will not begin until the time when the employee discovered or could reasonably be expected to discover the information which the employer tried to hide. Leave a comment below and let me know your thoughts. Stay tuned, continue watching. Thank you so much. So you have the time limit for equal pay claims in the court, as it were. Stay tuned, continue watching. The Supreme Court has decided that workers can bring an equal pay claim in a civil court rather than an employment tribunal if the worker has missed the 6 months time limit to make a claim in an employment tribunal. This means that equal pay claims can be made as breach of contract claims in the civil court, and there is a 6-year time limit, 5 years in Scotland, within which the claim must be made. Stay tuned, continue watching. Thank you so much. This may be particularly relevant to a worker who, after their employment has ended or after they have been transferred under transfer of undertaking, discovers that their former colleagues in similar jobs have received better pay or have been successful in an equal pay claim. Stay tuned, continue watching. Thank you so much for coming. If you have then subscribed to this channel, please subscribe to this channel and let me know what your thinking is. And we're talking about pay in the United Kingdom in terms of employment law. And leave a comment below if you know anything, or if you don't know anything about it. Is as good as you have arrived. And this is a prerequisite to your learning footstep. And I'm so grateful that we undertook to do this material. So continuing where we are, and if the worker takes a claim to the High Court, the losing party not only has to pay their own costs, but those of the other side as well, unlike in the tribunal where each side pays their own costs. The difference between tribunal and the court, leave a comment below. Let me know if you don't have money, if you're on minimum wage in the United Kingdom, or if you know anything about the minimum wage. If you have watched the rest of the video, I have spoken about a low level of minimum wage keeping the British people in poverty. If you're a poor person, can you realistically access justice or not? Leave a comment below, let me know. I think it is almost impossible for an ordinary citizen of the United Kingdom to access justice in terms of employment law, given also the condition of the politics of the public sector, where the legal aid has been cut and almost nobody is able to get legal aid. Even where the information says you might be able to get legal aid, the practicality, the complexity, the almost the impossibility of, the system is so complex that you can almost always fail to make sense of what is being said. Not only that, but also actually fail to use whatever material is being supplied by the government or by whoever supplies this information. But stay tuned, continue watching. Thank you so much.
Some see the original, mighty the god, the magical radical. Hey, representing my magical, young Jose come milli. And me go watcha, that lifta, you know teach me can you let me go papa. That watcha, you know damage me can you let me go watcha. That lifta, you know teach me can you let me go papa. That lifta, you know damage me can you.
So we'll talk about pay. So let us look at what the Supreme Court said about this situation we have been discussing. So the Supreme Court went on to say that if a claimant was found to have deliberately delayed making a claim to the High Court rather than the tribunal to try to gain an advantage around costs, the claimant risks having their claim struck out under the abuse of process rules. These rules are actually about processes. If it appears to the court that there is an abuse of process, and under these circumstances, the consequences are stated above. So if a claimant brings a claim to the High Court and not a tribunal, and the court decides that there was no reasonable excuse why a claim was not presented within 6 months to a tribunal, that could be taken into account when awarding costs. Stay tuned, continue watching. If you need to know about time limits for making a tribunal claim, you can visit the internet online and enjoy yourself reading this type of material online. So let us look at also time limits if the worker is on a series of fixed term contracts. We have been talking about fixed term contracts as a type of employment status if you watch the rest of the video about employment status, which actually determine your contractual status also, which provide you rights and obligations within the employment relational atmosphere. So if a worker works on a number of fixed-term contracts for an employer without there being a stable employment relationship, the 6-month period runs from the end of the contract. However, where the worker has worked for an employer periodically for a regular interval as part of a stable employment relationship, for example, a teacher who works for an academic year, then the 6-month period runs from the end of the last contract. Stay tuned, continue watching. Let us also look at the time limits if the workers is the armed forces in the military, and they have their own sets of conditions or rules governing their statuses. If the worker wishing to bring an equal pay claim is serving in the armed forces, they must first make a complaint under the service redress procedure. If you are in the army and you are watching this video, leave a comment below. And if you have been in a situation where there is a dispute of employment, then let us know. If they have left the armed forces, they have 9 months from the end of their period of service, in which they are there to present their claim to the employment tribunal. So we talk about time limit in the different sectors of employment, specifically employment status. And so we're looking at time limits if the workers is age under 18 and is of sound mind. Sound mind meaning you are not a mad person, you are not insane. Mentally, you are healthy, in other words. Where an employee is a minor or of unsound mind under a disability, the time limit to bring an equal pay claim is 6 months from the date on which they reach a 18 or cases to be of unsound mind. If you are a minor, I mean you are underage. You are not an adult, and you're also of sound mind, meaning you are not insane. You are in terms of mental health or mental illness. They are it. So if an employer deliberately conceals information from an employee who is under disability, the 6 months time limit runs from the date on which the employee discovered the concealment or could reasonably be expected to discover it, or from the date on which the employee ceases to be under disability, or whichever is later. Looking at time limits, if the worker is claiming a non-contractual benefits. If a worker is making a claim for non-contractual benefits, this should be made under the Equality Act 2010 and so brought within 3 months of the last act of discrimination. So the Equality Act 2010 is a type of statutory relationship in law. It's a type of primary legislative law. This time limit can be extended if the tribunal considers it is just and equitable to do so. If you want to know how to make more about making a sex discrimination claim, you can go online and read more about it. Thank you so much. Continue watching. Stay tuned. Subscribe to this YouTube channel if you haven't subscribed already. Thank you so much if you already subscribed. If you're watching this video, share it with family and friends. Be an ambassador. Leave a comment below if you think what I am talking about is sensible. If it is not, then let me know. Thank you so much. We are talking about employment at work and work in the United Kingdom. We are particularly talking about pay. In a successful equal pay claim, an employment tribunal can do one of many as below, make a declaration regarding the claimant's rights, and or order that their terms be made equal to that or those of their comparators in future, and or order the payment of compensation, for example, arrears or pay in a claim about, or and damages in a claim about some other contractual term, and at the tribunal's discretion award interest on any compensation awarded. Stay tuned, continue watching. Thank you so much. So arrears for breach of the equal pay legislation can generally be backdated for 6 years from the date on which proceedings are commenced. If you can get that successfully, then you will be laughing all the way to the bank. However, in England and Wales, if the case involves concealment, or the employee is a minor or of unsound mind, arrears may be backdated for 20 years. In Scotland, in general, the period is 5 years from the date on which proceedings are commenced, but any time when the employee was a disabled person or was induced by fraud or error by their employer not to bring a claim which might be ignored. Stay tuned, continue watching. If a successful claim is made under the Equality Act 2010, a tribunal can award a compensation for the financial loss your client has experienced. So if you are in such a situation, you will get the difference between what you were actually paid and what you should have been paid. Leave a comment below. Let me know your thought. Thank you so much. So let us also look at equal pay audits in England, Wales, and Scotland. In England, Wales, and Scotland, if an employment tribunal decides that there has been an equal pay breach in a claim submitted on or after the 1st of October 2014, it must order the employer to carry out an equal pay audit unless an exception applies. For example, the employer is a business which began within 12 months of the date of the equal pay claim, or is a business with fewer than 10 employees immediately before the date of the tribunal's judgment. This means if the employer is a small or medium business, and all the other circumstances are also applying. And stay tuned, continue watching, leave a comment below, let me know what your thoughts are. So we are looking at tribunal auditing, which will also not order an audit if an audit completed in the previous 3 years meets the regulations set out in law. If it is clear without an audit whether any action is required to avoid equal pay breaches occurring or continuing, the breach gives no reason to think that there may be other breaches, or but the disadvantages of an audit outweighs the benefits. Stay tuned, continue watching. So let us look at a situation. If an employer fails to comply with an order to carry out an audit, the tribunal can order the employer to pay a penalty of up to 5,000. Stay tuned, continue watching. So let we
you do my lenga, well, I'm yelling.
So let us look at equal pay code of practice in England, Wales, Scotland and Wales. The equal pay code of practice is available from the Equality and Human Rights Commission EHRC website. The Code of Practice provides a useful summary of equal pay law and practice. It provides practical guidance on pay. It provides a practical guidance on achieving equal pay without sex discrimination. And therefore, the code includes information on grievance procedures and equal pay reviews. It is not legally binding in employment tribunal proceedings, but a tribunal may take into account an employer's failure to follow its provisions. Stay tuned, continue watching. Let's look at the Equality Advisory as a support service, EASS, in England, Wales and Scotland. So Equality Advisory Support Service is a kind of a body. The Equality Advisory Support Service, EASS, helpline is for people who may have experienced discrimination in employment, housing, education, transport, and all other goods and services in England, Wales, and Scotland. It also covers human rights. It is not for employers, service providers, or educators. It supports individuals referred from advice agencies and other community organizations. Individuals can call the helpline directly, but it is preferable that they go to an advice agency first. Thank you so much. Stay tuned. Continue watching. So the helpline will explain what the law says and how it applies, and explain how the situation could be resolved. It will not provide legal advice or representation or advice on the strength of a case. The contact details are online. If you are interested, you can access gov.uk and look for Equality Advisory Service, a support service, EASS, helpline. They are free. You can also send post to them on free post. You don't pay for the postages. EASS helpline. And the numbers and all the referencing, they are open Monday to Friday, 9 a.m. to 7 p.m. Sunday, also on Saturday, 10 a.m. to 2 p.m. It sounds to me like a pretty good service, so you can use the contact form on the EASS website. And also you can visit their website www.equalityadvisoryservice.com, and you can also get further guidance about discrimination is still on the Equality and Human Rights Commission website. And stay tuned, continue watching, and let us look at what happens in England and Wales. Advisors can use citizens' advice specialist support to help take discrimination cases. I've mentioned citizens' advice previously on this program. I've also mentioned government website gov.uk, and also reminded people that this is international resources. If you are anywhere in the world with internet, you can access the citizen advice, especially public website, but all in particular you can visit the website directly. So in Scotland, some of the specialist support projects or agencies may be able to help with discrimination cases. Stay tuned, continue watching. Thank you so much. And we are looking at the Equality and Human Rights Commission's EHRC helpline for advisors only. Also, if you are an advisor like me, then you can access these numbers on the Equality and Human Rights Commission in England and Wales, and also in Scotland. So in England, Wales, and Scotland, the EHRC runs helplines for advisors only giving advice on discrimination. These details must not be given to clients. So the contacts is below. You can access it. Most advisors avid. If you're an advisor watching this, would be an avid researcher, so there should be no problem at all. But like I said, somewhere along the line you will find this information. If you are in the UK, if you're not in the UK, then fair enough. So let's look discrimination or sexual orientation discrimination, and also these are some of the things you can talk about. Equality and Human Rights Commission, EHRC advisor Everland in Scotland, and you can visit their website. You can also email them, and you can look at their telephone number Monday to Friday, call office hours, and etc. etc. You can also look at gender pay reporting if you are an advisor. This is information for advisors. So gender pay reporting is about the difference in pay between men and women in the workplace. It's not the same as equal pay and doesn't relate to specific job as with equal pay. For example, it might show that women earn 15% less than men. Stay tuned, continue watching. Thank you so much for watching this material. So since the 5th of April 2017, private and voluntary sector employers with more than 250 employees have to report to the gender pay difference between their male and female employees. In England and Wales, public sector employers have had to report the gender pay difference since the 31st March 2017. In Scotland, public sector authorities with more than 150 employees have had to report the gender pay difference for some time. This duty is gradually being extended to cover all Scottish public authorities with over 20 employees. This change is coming into effect between 2016 and 2018. You can read more about these dates. Stay tuned, continue watching. So the mean gender pay gap in hourly pay, the median gender pay gap in hourly pay, the mean bonus gender pay gap, the median bonus gender pay gap, the proportion of men and women receiving a bonus payment, proportion of men and women in each pay quartile. Stay tuned, continue watching, leave a comment below and let me know what you are thinking. In England and Wales, employers have to publish this information of their website by the 12th of March 2018, public sector or the 4th April 2018, and also private and voluntary sector, and then once a year after that, then they also need to send this information to the government on gov.uk. You should be by now, if you've been watching my video, familiar with gov.uk. I've been mentioning it over and again, and you can read more about gender pay gap reporting on gov.uk. In the United Kingdom is the government website which anybody can access publicly, and also if you go to Citizen Advice, if you're lucky, or you are unlucky, you might also get really useful information on the public website. And stay tuned, continue watching. In Scotland, you can read more about gender pay gap reporting in the public sector and more about gender pay reporting in the private and voluntary sector. Thank you so much. Stay tuned, continue watching. So let So thank you so much for coming this evening, this morning, wherever you are in the UK. We are in the early hours of Saturday, and we have been talking about pay in the United Kingdom. If you work for a living, you get paid. And continuing next time we meet, we will continue to talk about pay in its more detail. If this is not detailed enough, leave a comment below. Let me know what you think about this material. I find it to be a lot of information, and they are online. You can always find them, and like I said previously, it seems like a tedious exercise, and it is, but we live in an age of knowledge, and information is very important. Knowledge is power. If you're a young person, if you're an adult, if you're a pensioner, if you're working of a working age, this information about work in the United Kingdom and also about pay is important, because sometimes what happens to you when you leave work as a pensioner, or you leave work because you are maybe moving from one employer to another, and there is always bound to be a problem involving pay, and pay is the essence of work, because if you're not paid properly for one reason or another, and maybe you are paid but you are paid low, maybe the employer is trying to manipulate government laws, say for example on national minimum wage, where you may be in a situation where the employer is trying to increase the number of hours you work without increasing the pay. Contrary to the contract, if you are working part-time, some employers can increase your working hours and recalibrate to pay you low to work more, because minimum wage is low. You have mentioned this. Employers use it to even exploit employers more, to lure employers who are working part-time into with higher level of pay. But because of the complexity of the intricacy of the law and so many loopholes unplugged, whether deliberately or not, it is so difficult. My opinion has always been that the law is so complicated that even people who create them do not know what the law is, and even lawyers themselves do not no longer know what the law is, and it's like a beast out there, and it's something we have to deal with. And if you are a resident of the global community, you should be an expert on the law, especially law of employment, but also any law on health service, housing, matrimony, if you're married, if you're single, on immigration, on debt. All these sections are actually governed by law, and the law is so complex. We created them, and legalism has always been contrary to peace. And I've said this in the other places on this, in the videos on this platform. So thank you so much for coming. And next time we meet again, we will be talking more about the different situations involving pay. If you haven't subscribed, if you watch up to now, you are such a fantastic champion, and subscribe to my YouTube channel. Click like, click notification bell, and let me know what your thoughts are. Leave me a comment and click the notification bell, subscribing, and sharing video if you watch them, sharing them with family and friends. We'll see you in the next video. Thank you. Bye bye.
Some see the original, mighty the god, the magical radical. Hey, representing my magical. Young Jose, come milli. Amigo wacha, that defta. Kina teach me kenyo amigo kopa. That wacha, kina damage me kenyo amigo wacha. That defta, kina teach me kenyo amigo kopa. That defta, kina damage me kenyo.